have another public hearing
Right.
next month and retain it.
You have
I'm
to,
willing certainly to do that, Justice.
I don't have a problem at all in that either.
I think we need to have a confidentiality rule. I agree with that. But our court rule provides, our administrative order provides that we need to get public comment first, unless there's a need for immediate action, and I see nothing that requires immediate action before us today. We have Canon 3A, A6, which has been in effect for nearly 2 decades, which talks about justice not be able to talk about pending or impending cases. And if there was a need for an immediate action, why hasn't
is.
an
Just-
amendment, what is the what
She
is the
says
need?
that rule, she said, was voluntary. She can abstain or not at her choice.
Yes, with all due respect, Justice Hathaway, it's my belief that because we have a situation where all the justices are unwilling to attend meetings, that if we were to pass this on an emergency basis today, that we would do away with the objection to attending meetings. That, to me, constitutes an emergency that needs to be handled right.
What does this mean, Chief Justice Kelly? Does this mean that there's been any gap?
I'm not talking about a gap. I'm
Well,
trying to...
No, I mean,
No, but
if we enact your proposal, is that a statement effectively that there's been a gap in coverage?
What we're proposing, what Justice Kavanaugh has effectively proposed, is that my motion is a new rule, which is an emergency, which would be acted on an emergency
But there are
basis.
4 people who believe that the current rule is in effect.
Well, it's always been effective.
Yes, it's always been.
5 people.
Oh, okay, I didn't know 5 people. But my point is, I'm not averse to your amendment, but I don't want to vote on it if it means that I'm abandoning my belief that AO 2006-8 has ever suspended its effect.
Then what would be its
You
purpose
wouldn't have to
otherwise?
abandon your belief.
The mere fact we're amending it means it's something in effect.
All right. With that under clarification, I support
Support
it.
it on an emergency
Can we
basis.
vote on this then?
I'd like some further clarification. I don't understand that, and I don't think it's something I want to gloss over. Has this been in effect since 2006? In fact, has there been a rule in effect since 1837, as with every other court? I mean, has there been a gap? I just don't understand the answer. I've heard 3 different answers. Has there been a gap in coverage?
I don't think so.
Is the purpose of this to create a gap
No.
so that...
I think our rule, it's wishy-washy language. I mean, if we had wanted to say there's got to be a second vote after the public hearing, we should have put that language in there. It's
Right.
not in there.
Right.
So that's my basis for saying it.
And
it
there are
was in
3 others
effect,
who agree with
and
that.
this is amending it.
Okay.
I still don't
I
understand.
just
Is
think
there
you
a
should
gap?
have orderly process and be clear process.
So,
I guess, let me
so
put
is
the
this
question
going to
in.
be put on the next agenda then, at our next public hearing to,
If we adopt it as an emergency, yeah, it goes on the next.
Public hearing, and then after the public hearing, I would suggest we vote on it.
Chief, there's been
Well, I would like-
a referral to the JTC. That referral has identified a number of provisions that arguably have been violated. Would it continue to be the case that 2006-8 should be one of those provisions?
I'm not sure of that. The court has never settled, I think at around the time that came up, as to what the remedy is for a violation. I mean, is it something that can be referred to?
We're not
the
doing the
JTC?
remedy here. We're just,
No, I know it.
We're just trying to figure out, do we have a rule that's in the books that's enforceable or not? What the remedy of its violation is not our concern. I mean, I don't know that it's definitely been violated, but there's a referral. And I'm worried, as Justice Markman is, that the whole purpose of Justice Weaver's motion is to create a gap. And I want to be sure,
Well, that motion failed.
I know,
so
but I want to be
see
sure
your
that
concern.
there are, as I hear it, Justice Markman, Justice Corrigan, and Justice Kavanaugh and I believe that this AO 2006-8 has been effective from its initial enactment. That's right. Okay.
Well, I'd like to know what prevents Justice Weaver and Justice Hathaway from coming up with another clever argument in 5 years that what we've done here doesn't make this effective. I mean, that's exactly what's happening today, clever
I
arguments.
stated on the
Are we
record
going to have a clever argument
said-
5 years from now?
that it was not properly adopted.
I understand you
stated
said
the
that.
rule, it shouldn't be in effect, it was never properly adopted.
I understand your argument, and I don't
No,
agree with it.
retained.
Well,
Could we call the question on my motion at this point?
No, I'd like to have a statement or
Sorry,
two
go right
about this. Obviously, I disagree with most of what Justice Kavanaugh says, other than he questions whether the thing is effective or not. It was, if it's a period, it wasn't. I obviously believe the court is wrong, and that this order was used to suppress a dissent, so it's unconstitutional, against our Constitution, which requires that we give our opinions in our dissent. And also, I think it is in conflict with the canon that nobody seems to disagree that we have. And I have not said that in general, and I don't know that I've ever violated with respect, unless somebody's going to accuse me today for telling the truth here, but that while a case is pending or impending, which is what is in the language of the canon, that I respect that. If you look at my dissent, which is on my website, to the 206 adoption of it, you'll see that I always respected that, but not because this court should be secret, while it's because this court cannot deliberate and cannot do things in public. It was because I didn't want to become a political football by other justices or outside parties. That's why we have that reason that you would abstain. But you wouldn't always abstain with respect to the case, and you're only supposed to abstain as to the substance, not the procedure. In any case, I believe in openness. I'm willing to do the public's business openly, not secret.